everyone, this is Laura.
And Jess.
And Eva.
This is just a quick heads up. So, we're students, not legal professionals. This podcast is all about discussing interesting law cases, judgments, and sharing our own opinions.
Everything we talk about is for learning and entertainment purposes only, so please don't take it as legal advice or use it as an official source.
Always double check facts and refer to credible legal materials if you're researching or studying a case.
Thank you so much, and I hope you enjoy the episode.
Hi guys, my name is Sarah.
I'm Mohammed.
And I'm Fatima.
And we're all second year law students at the University of Edinburgh. Today we're going to be talking about the R and Brown case, 1994, 1AC 212. Today we'll be talking about quite a controversial case, so I just want to give a disclaimer. We are discussing quite sensitive topics and themes, so if this is not something that you are particularly comfortable with, then I would recommend not listening to the episode. But yeah, let's get into the case. So at the heart of this case, it's about the legal boundaries of personal anatomy, specifically whether an individual can legally consent to being injured by another person for sexual gratification. And to paint you a picture of what this case entails, just imagine the police entering a house for a charge which is unrelated to this case and finding videotapes. And in these videotapes, the videotapes contained sadomasochistic acts, which included quite aggressive acts such as genital torture, violence directed at the anus, penis, testicles, and nipples, as well as bloodletting. And in one instance, a part of the body was actually nailed to a board, though not so severely as required medical treatment. And that is kind of important in this case, the fact that no medical treatment was required and all of the equipment was sterilized as well. And then a crucial defining characteristic in this case is consent. All the participants consented to the harm that they received, and none of the men involved ever complained of any of the acts. Despite the severity of the acts, the victims suffered no permanent injury. The entire investigation was triggered by an unrelated police investigation. And the ultimate question for the court was where the law draws the line between private consensual activity and criminal assault. So I'll be giving the mic now to Awami, Mohammed, who is going to be discussing majority judgments.
Thank you, Sarah. Okay, so this went all the way to the House of Lords, the predecessor to the UK Supreme Court. So 5 judges litigated this case, and it was decided on a 3-2 judgment that consent is not an offense in this case of sadomasochism behavior. So 3 judges who agree that consent is not a defense include Lord Templeman, Lord Jauncey, and Lord Larry. So just to briefly go over what each of these judges have said, Lord Templeman took a very socially conservative view in relation to this. He ended his judgment by saying society is entitled and bound to protect itself against a cult of violence. Pleasure derived from the infliction of pain is an evil thing, and cruelty is uncivilized. So he very much saw this not as the appellants wanting to have sexual gratification, which is part of the defense. He saw this as, this was just violent. Sex cannot be used as an excuse for violence, and society should protect itself against this cult of violence, as he called it. So he very much saw as restricting this as a moral duty, and how Parliament didn't conceive of this in the legislation. And so ultimately you could say that it was a moral reason why he didn't allow consent as a defense. Moving on to Lord Jauncey, he was mainly focused, I would say, on the public interest. This idea that if this type of activity is allowed, who knows the effect this could have on society as a whole. And one thing that he also considered was that this idea that this is a violation of your private or family life, which is a right under the European Convention on Human Rights. But he said that sadomasochistic homosexual activity cannot be regarded as conducive to the enhancement or enjoyment of family life. And as Sarah mentioned earlier, the equipment was sterilized. There were precautionary measures taken to ensure no one would get hurt. But he argued that these people were not medical professionals, and the fact that no one got hurt was more based on luck rather than skill. And there was very much a likelihood that someone would get hurt, such as contracting AIDS. So very much a public interest judgment here. And then Lord Lowry, he essentially I would say, agreed with Lord Johnsey. He didn't really add too much new, but ultimately the majority judgment concluded, based on moral grounds, based on the public interest, this is a conduct in which you cannot use consent as a defense. And now we're going to move on to Fatima to talk about the minority judgments.
Thank you, Mohammed. So in this case, we had two judges that dissented with the majority agreement. So first of all, we have Lord Mustill, and I found his argument quite interesting and quite convincing, as he was able to separate his own moral stance from his legal duty as a judge, which is something that we'll discuss later on. But he essentially says that the Offences Against a Person Act, which they were convicted under, was not designed for cases like this, and that if we kept applying it in all situations like this, then it would undermine its legal certainty. So that raises some questions about that. And he also grounded his reasoning in private autonomy, saying that they made informed and consensual choices in a private setting. And therefore public interest shouldn't be a major concern. And he was quoted in the case saying that these are questions of private morality and that the standards by which they fall to be judged are not those of criminal law. Moving on now to Lord Slynn, the other dissenting judge. So he essentially did agree with Lord Mustill on the autonomy point and the undermining the legal certainty point, but he more emphasised that his dissent came from the fact that this was a matter of policy for the legislature to decide rather than the courts. And he drew a kind of clearer doctrinal line, saying that you can consent to actual bodily harm, but not grievous bodily harm. So essentially, he's drawing a more principled limit, where if no permanent or serious injury arises, then consent should stand and it's not for the law to get involved in. So now we're sort of just going to open up a discussion about what we think of the case, what we think of the judge's decisions, and whether consent can act as a defence to harm. So what do you both think?
Okay, so the thing is, this case is quite difficult to give an opinion on because there's just so many themes in this case. I don't think a single judge had the perfect judgment, if that makes sense. I feel like overall, I do believe that the public interest at heart, I think that is something that I do agree with quite strongly. But at the same time, I do think that obviously Lord Templeman didn't need to use certain adjectives in his judgment. Because it turned into more of a moral battle instead of like staying quite legal.
I think I pretty much agree with a lot of that. I mean, I would say when it comes to Lord Templeman, yeah, he definitely brought in this sort of moralistic idea, which I don't think judges should be able to do. It's not for judges to decide what's morally right, what's morally wrong. That's not the whole point of a judge. Like, they're meant to look at the law, assess the law the way it's written. You know, wouldn't be democratic for judges to be like, okay, we're going to decide this is morally okay, this shouldn't be legal. But I think, despite my disagreements with him, I do overall agree with the judgment. I agree with Lord Johnsey and Lord Lowry in the sense that the public interest is ultimately very important here. This idea that if we are going to say consent is a defense here, we're opening up the flood for other people to take part in these activities and use this case as precedent. Like, okay, like people are, if we're allowing saying we consented to this to ourselves, there's no problem with that. But obviously, like we've seen from the facts of the case, the specifics that they did, like this is genuinely really violent stuff that could have easily led to HIV, AIDS, injuries. Like especially if you're not a medical professional, like God knows the injuries this cause in the future.
I think I find it really difficult because while I do agree with everything you said and the worry about setting a dangerous precedent for people to kind of consent to harm in the future, I think that the law shouldn't operate on a what-if basis. So in this case where there was no kind of grievous injury and the parties were consenting, I think it's really crucial that they didn't complain, and I think it kind of undermines their autonomy to say, oh, we're just going to convict because what if something had happened? And I think like if something had happened, then we can take it from there and discuss. But I think the law shouldn't intervene on a kind of what if hypothetical basis. I think that's what I find a little bit difficult about this decision, because there's so many other cases in law where you could just say, what if this could lead to this could lead to that, and I think that might be opening up doors on the other side of things. So honestly, if I was a judge in this case, I would really, really struggle with sort of how to balance all of those considerations, for sure.
I mean, it is definitely difficult, and what a thing that is a valid argument. But one thing that I want to bring up that you mentioned, this idea of we all consented. I think we also need to consider in this case. I don't know if it was mentioned yet, but like it was said of a judgment that one of the applicants, like he was a minor when he was introduced to this stuff initially. I think that's an important part of the judgment that hasn't been taken into account yet. And ideally, even if you do consent, there's obviously this chance of exploitation, and there's a lot of cases, unfortunately, where people don't complain to the police or don't consent simply because they feel exploited. They've been subjugated to believe this is just how the way things work. Like, so I feel like then if we're gonna apply that standard here, then you can easily say for like a domestic abuse case, this person allowed for them to go for this. They didn't complain to the police, so you could easily. So I'm not defending it, but obviously I'm just saying I don't think saying the idea they consent if they didn't complain is the most applicable argument.
Yeah, I just want to add that, like, I do agree with what you've said, Fatima, what Fatima has said. I do think that it's wrong that this case was used as almost like an example, which I don't agree with. I do think that they should have been. It's just not fair on them to be charged on the base with any sort of moral themes even involved. But at the same time, I do think that the risk that it can, as Mohammed said, like open a floodgates to violence, is quite a big risk that the judges do have to take into consideration. I do know that judges do have to work with a legal mindset, but at the same time, public interest does have to be sometimes involved in the judgment. And I do think that if you think about like the level of violence, especially in this case, it is quite severe, and it was all consented to. They did use safe words, and like everything was sterilized, and there was no permanent damage. It's so difficult, honestly. Like this case is so difficult because on one side you do have, well, all these acts were done privately. It was all consented to. There was no permanent damage, and but at the same time, the legislation of like actual bodily harm was kind of, and also when you break the skin, wounding, they were both involved in this case. So yeah, I do agree that obviously like it is quite difficult to, I guess, use just this case as a way of saying that the public could be at risk, but at the same time, the public could be at risk. If that makes
I
sense.
think what I find like difficult with this case is that maybe it is kind of really risky to be opening these doors for this behavior, and I think I would maybe find the majority judgment more convincing if I genuinely thought that public interest was what was at the core of their decision. But when you read the case and some of the language that is used, there's just kind of this implication that the judges have made a decision on the basis more of moral disgust rather than public interest in the law and in precedent. And I think setting all morals aside of whether we think this kind of violence should be condoned or not, I think that the judge's key consideration should always be the law. And I think what I find particularly difficult is when you look at other cases in other crimes where there's such like a massive like evidential burden and all this proof to prove that someone has committed a crime, especially in like other sexual offences cases, whereas in this case harm didn't even occur and they're being convicted. I just think there's this massive discrepancy, and that's why I think I don't know whether I disagree or agree fully with the majority judgment, because I think especially when it comes to Lord Templeman, I do understand his point about not being able to tell the degree of harm that will occur. For example, like a small blow could escalate, but it didn't in this case, and that can also be refuted by the use of safe words. And I think him comparing it to drugs is also mistaken, because the only reason that this case became like a matter of public interest is because they saw it as kind of disagreeing with societal values and moral values rather than it being an actual public epidemic like drugs, for example. So I think I just did not find the majority argument convincing at all. I think they could have really argued it a lot better if it was in legal interest.
Also, I do agree with the fact that the law does kind of um, limit, like the law doesn't act equally in other cases, especially with the case where the couple, the husband, so the heterosexual couple, where the husband was branded his wife, and consent was used as a defense in that case. People, you could see this as being almost having themes of homosexuality, because at the end of the day, the branding was derived from gaining some sort of sexual gratification, which was exactly the same in this case. Consent was given. It was, I guess, a safe environment. Even though it was extremely violent, it was a safe environment. No one was permanently damaged. But at the same time, defense was seen as not being, consent was not seen good enough.
Yeah, in that case that you're speaking about, R against Wilson, I think it is R and Wilson, 1997 QB47. There was a different decision reached, so you could question whether it was to do with the fact that it was a homosexual activity rather than heterosexual couple, because there was a quote in R and Brown where one of the judges used the word normal heterosexual couple, which does imply that there was some homophobic undertones, and that influenced their disgust at the behavior.
I can't disagree with that. It wouldn't surprise me. This is the 1990s. The judges are probably very conservative. So I wouldn't be surprised if there are homophobic undertones in this judgment. But I think something that I want to address and stuff that you said, Fatima, was the idea of, I mean, for example, in criminal law, there are offenses in relation to gross indecency, like public indecency, I believe, unless I'm mistaken. And there's a lot of subjective elements in law already. There's a lot of cases, a lot of times in law where judges have to kind of give a subjective view, essentially a subjective view, on what a reasonable person would say, for instance, or if this is in the public interest. So I think we can agree Lord Templeman's judgment didn't really align with that. But when it comes to Lord Chauncey and Lord Lowry, I do think they did a decent enough job, I guess you could say, kind of talking about this public interest, and ultimately how I definitely have a stronger view, much stronger opinion in agreement with this case, because I just I just feel I know you're not meant to have morals, you're not meant to really put morality with law, but I just feel like in this case specifically, I just personally feel incredibly uncomfortable allowing this type of act to just be legal, because consent was given, whether it was a homosexual activity or a heterosexual activity. Like, I just feel it's very uncomfortable. I just feel it is very uncomfortable. It could be incredibly dangerous, even if it is done privately. Just because something is done privately doesn't necessarily mean that it's okay. Something illegal can still be done in the bedroom, and maybe people won't know about it. Doesn't mean it's legal.
Surely, if the risk of making this behavior illegal or condoning it was so high, surely they would have taken action to kind of refer it to Parliament to have it maybe incorporated in statute, or they would have reflected this in further. That's the main issue I have, is that they talk about this risk of setting precedent, but then they don't follow that same decision in R and Wilson, and they didn't take any action to incorporate it into statute. So I think again, it doesn't align with their reasoning, I think.
Yeah. That is a perfectly fair point. I guess here you could definitely argue. I mean, let's be some of the legislation they mention here is based on from the early 1960s, early 1950s, even the late 19th century. I believe Parliament realistically wouldn't have considered this type of behavior, because they would see, naturally, Parliament cannot put in legislation every single potential behavior that could occur. But I think either way, even if Parliament didn't put it into statute, we can definitely infer based on debates, based on society views, Parliament wouldn't allow this type of behavior to occur. But just because something isn't put in statute doesn't mean it's not covered. But it's not covered by the law. It's not covered by the law because it's possible to put all these scenarios, and there's just some stuff that's so outrageously, like, the average person wouldn't be doing that. There's not necessarily need. I definitely do think, yeah, this Parliament should have taken action, and R.V. Wilson should have.
Yeah.
I'll continue.
I also do think
Guys, I
that,
need to
like,
go now, unfortunately.
so yeah, Mohammed, do you want to say why?
I guess I think that's pretty much everything that I wanted to say. But I hope you guys enjoy what I had to say. Feel free to disagree as well.
Thank you.
Thank you.
Guys.
I just wanted to quickly add that at the end of the day, I do think that there are some people in society with quite evil intentions, you know. So people might consent was used as a defense. I do feel like some people might use this case to inflict or use this case in more abusive cases. So there was like a similar case, I think it was Aaron Donovan, where a 17-year-old girl was beaten and consent was, you know, used as a defense or tried to be used as defense, where it's like, if you think about it, the only main differences between that case was obviously age. The girl was a minor, but age, gender, and I guess sexuality, but that was the only main difference. So there was nothing else, which is, you know, I guess there's no other major differences between that case and this case, and that was quite an abusive case. So yeah, it is really difficult. Overall, it is really difficult to say if consent can be used in private matters like this.
Yeah,
I don't know.
I think that's what just makes things in criminal law in general so difficult. Is that, like, you know, obviously once something's in statute, it's very black and white. And like you said, it can be very much exploited by people with evil intentions. So I do very much understand the judge's kind of reluctance to not convict on this basis. And I think that's what makes cases like this so difficult and so interesting as well. I guess just to finish, this is a question that we actually did in one of our tutorials, but in general, do you think that the law should prevent us from consenting to harm? What do you think?
Again, like, that is quite a difficult question because you can't really ignore the whole private and public theme of it.
Yeah.
So it's kind of like, if someone was to consent and it's a private matter in someone's, you know, home, can the law even interject in that? Does the law have any right to interject in that? Does the law have any right to that? Which is something that you can't ignore in any case or any sort of, you know, in anything to do with harm being consented to, because most of the time it's not done in public, it is done in private. So it's quite difficult to answer that question.
It is really hard to bridge that gap between, like, protecting people from maybe consenting to these kind of things and it being used as defense, and also, like, upholding the idea of, like, autonomy, because clearly in this case, like, it was just something they did all want to do. And I think my personal take, and I think this would be really complicated to incorporate into law, is that, like, consent shouldn't be a defense when it comes to things like death and very serious injury, which, again, how do you even define serious injury? Everyone maybe has different thresholds and you can't just put a blanket definition. But also, I guess when it comes to, like, public order situations where wider harm arises, consent shouldn't be used as defense. But then the issue comes again, like, what counts as a public issue? Because the judges seem to see this as a public issue, even though, well, they wouldn't have even known about it if they weren't investigating their home for a drugs charge, something completely irrelevant. So it kind of just became a public issue by chance. But I also think when it comes to vulnerable people, like not adults or lacking mental capacity, and also having being, like, coerced, I think consent shouldn't be used as a defense. But in this case, there was no evidence of coercion. There was nothing that anyone would have gained from consenting other than their own kind of, like, sexual gratification. There weren't vulnerable groups other than, kind of, as Mohammed discussed, like the minors. But the main parties involved were consenting adults with full mental and legal capacity. So I think if those factors had applied, consent should definitely not be used as a defense. But it'd be interesting to see how this could be, like, incorporated into law as a whole. So
I just wanted to quickly add, I do think what you said about what is the, like, how can you define extreme violence? Like, how can you define like, how can you cross that line of violence being, I guess, to the point where the law can step in, if that makes sense. And I think that is one of the main issues in this whole case. Like, what can you define as extreme violence? And I just wanted to add, so in terms of ABH, so actual bodily harm, it can be consented to in certain contexts, such as surgery, boxing, and tattooing, for example, which was used as a defense by the appellants. And Fatima, what do you think about that?
Yeah, I think it's really important to kind of say, like, is this more similar to those kinds of cases, or is it distinguishable? I think in the Aaron Wilson case that we mentioned earlier, they used that as a defense, because they said that the branding was more similar to tattoo-like activity. And I think if that kind of very, like, narrow definition is to be used in a case like that, where, to be honest, the branding was also for sexual gratification purposes, I think that in this case, you could sort of argue that it's the same as sort of like consenting to being in like a boxing ring where everyone is involved in the same level of violence and everyone has the same risks involved. I think there's a lot of similarities and differences you can kind of draw between these things, which is what makes it difficult. I think when it comes to medical procedures as well, there's a lot of similarities and differences you can draw. But then the worry with that, if you kind of compare it to that, is that like other instances of violence, like the Donovan case you mentioned earlier, can then also just be used as a defense with that. So I think that's what makes it quite tricky. And maybe it would be more simple if the law just did keep it to medical procedures, tattooing, and sport. It's quite tricky.
Yeah, I completely agree with that. It is really difficult. I personally think that I think that we should put more focus on the reason for the ABH, the reason for the actual bodily harm. Obviously, in surgery, there's a benefit of quite a large benefit to the actual bodily harm in that moment. But then at the same time, you could argue that sexual gratification is, I guess, a benefit to people, but at the same time, I don't know, it's quite difficult because in boxing, for example, the benefit of getting in a ring and, being, the sport itself is mostly, I guess you could say, business, so financial gain, and also just kind of gratification as well, but just not in a sexual way. So why can't that be used? And also just the theme of it being in a controlled environment. For example, surgery is extremely controlled. Anything in the medical field is going to be extremely controlled. You have so many measures put in place to make sure that environment is sterilized. You have professionals on hand if anything was to go wrong. Everything is controlled. So you have a very extremely controlled environment. But then you could also compare that to the case itself. So the environment was sterilized. They used safe words. So if anything was to go wrong, they were able to pull out. They verbally consented, and there was no permanent damage. So there was further evidence, even longevity, in terms of how controlled that environment was. So it kind of, do you want to add anything to that?
I think like with your point about them doing it in a controlled and safe environment, I think that like obviously there's a worry that like, well, just because they did it safely doesn't mean that everyone else will, and if we just let everyone do this, then there would be so much injury. But I think then it would be unfair to like let the parties in this case kind of like take the hit for like everyone in the future that's going to be doing this, because well, they did do it safely. But then I also think, when it comes to things like boxing and like medical procedures, if something goes wrong, the law doesn't interfere. It's very much, it's kind of like, oh, that's on you. You chose to do it. And do you think like a similar principle should apply to this case, where if the harm had occurred, it's kind of like it's on them, it's their problem rather than the law's problem?
I don't know, it's quite difficult because I do think the law can intervene in certain medical procedures which can go wrong. If I don't know, they were to miss
like medical negligence.
Exactly,
and things,
medical negligence and stuff like that. I do think if something were to go wrong, it is a private matter. So it's quite hard to say, like, at one point in time, from the beginning to the end, can the law intervene? Because at the end of the day, they're the ones who committed the act, so they're the ones who committed the violence, and then the law hadn't intervened or wasn't able to intervene, and then just because there was some sort of long-term harm, I don't think the law should be able to intervene, because it's still a private matter, if that makes sense.
And when you think about a boxing match, when you think about what they're actually doing, it's obviously it's different from a street fight because it's in a controlled environment, there's the sport regulations, but they are inflicting very serious harm on each other, and the fact that they consent is enough. But I also think like another reason why boxing matches and extreme sports are seen as okay is because they're kind of something that I guess have over time been come to see as like something entertaining and very like
less taboo.
Like a lot less taboo, and it's like for the gratification of the people that are performing it and people like watching it, but that kind of probably was only again achieved over time, like how any kind of like social standards are. So I think when it comes to this, I remember one of the judges saying that they were kind of engaging in harm for no good reason, but you could kind of argue that the principle of sexual autonomy is a good enough reason. In the other sexual offences that we've studied, the like main thing running through it is that like sexual autonomy and consent should always be balanced and should not be undermined, and that's always been a key issue. But I think you could argue that if we're letting people consent to punching each other in a ring just because the public think it's okay, then maybe we should rethink this, kind of in line with like social standards. So it's definitely interesting food for thought.
No, I completely agree with that. Okay, yeah, so we're coming to the end now. I just wanted to close with the fact that these cases, well, for me personally, are so fun to read and so interesting because your opinion changes so much throughout reading the case and going over the case, hearing the judge's views, and even hearing cases which are related to this case or used in these cases. I feel like these cases, you're not supposed to have one opinion. It's almost one of those where your opinion is supposed to change. So I do want to say to anyone listening, have an open mind when dealing with this case. Is there anything you wanted to add?
And I think even though there's a lot of themes that we've discussed, when it comes to actually answering this in an exam setting, just kind of remember that like the key legal issue at the core of the case is whether consent should be used as a defense to harm. But then obviously that does bring up a lot of other points for discussion. So you can definitely discuss all these other points, but just keep in mind that that's the main point. And yeah, I guess you can just kind of use it as food for thought for whether you think that principle should apply generally across the law, and to kind of see how, even though it's an English case, there's a lot of really important things we can think about when it comes to Scots law as well. So I hope that you've enjoyed listening to our discussion. I definitely really enjoyed talking about this, and my own opinions have changed a lot from listening to even things that Sarah and Mohammed had to say. There was a lot to think about there. So I hope you enjoyed it as well.
Yeah, I just wanted to also I have a question. This is like a certified question, which I think summarizes everything. Which is, where A wounds or assaults B, occasioning him actual bodily harm, which is ABH, in the course of sadomasochism or sadomasochistic encounter, does the prosecution have to prove lack of consent on the part of B before they can establish A's guilt under Section 20 or Section 47 of the Offences Against the Persons Act 1861? I feel like that's quite a good way to kind of structure your answer in an exam. Always relate it back to the act. But yeah, I think this discussion has been so fun, and I completely agree. I've changed my mind so many times listening to you guys, and
thank you
so much for listening.